Okay, good afternoon. I'm Chrissie Scelsi, and it's just about 4, so I thought be a good time as any to get started. Thanks for coming and spending some time this afternoon. I'm here to talk to you, as you can see, about some intellectual property, privacy policy, and open source licensing issues, and that can come up when you're dealing with WordPress or web development, and just in general. To give you a little background on myself, I'm a local intellectual property and entertainment attorney. I also used to work for a game-based simulations company, and so I've ended up in software licensing and those various things. And I was explaining to my mom the other day about a project I was working on for a client, and she was really excited until I explained to her what an open source software license audit involved, and I could literally hear her eyes glazing over. But anyway. I'm very excited to be here, and without further ado, let's get this underway. So to start with intellectual property, just so we know what we're talking about, and you'll see these, even journalists get these confused sometimes. So we want to know what we're talking about. So you have copyright, and this protects the expression of ideas. So these are songs, pictures, artwork, literary works, actually source code, and computer programs, which are actually can be classified under copyright as literary works, but that's a story for another day. Anyway, copyright's your expression of ideas. Trademarks, these are your source indicator. These are logos, phrases, things that identify where you're getting that can of beans from. And then you have patents, and these are more your inventions, business methods, and to answer a common question I get all the time, how do I protect my idea? Well, there really isn't a way to protect your idea. You can do an NDA, that's a good bet, but really, you want to get your IP. Protecting your IP protects iterations, as you can see, iterations of that idea, but to protect an idea, there's not exactly a straight shot way to do that. But anyway, so to start with copyright, it's really simple to invoke. All you have to do is fix the expression of an idea in a tangible medium. And this can be writing it down on paper, it can be creating art, or it can even be buffering, our favorite when we're waiting for our Netflix or our Hulu to load. It's always fun, buffering. But even that millisecond is enough to be considered fixation in a tangible medium. So it's really simple to invoke, has a long period of protection with it. You get the life of the author plus 70 years if you have a single author. There's different classifications if you have joint authors and anonymous authors, but I'm just doing the 30,000 foot view right now. And there can be serious penalties to infringing copyright. The maximum penalty that you often will hear about is the maximum is $250,000 per offense. For that to be invoked has to be a pretty egregious infringement, kind of like your Napster or your Grokster, where you're infringing tons and tons of content, and where you've probably made some large media company upset. Typical fines, you still want to avoid dealing with this, and I'm all about arming my clients with knowledge. But your typical fines are more along the lines of $2,000 to $3,000 per offense. So what do you get with a copyright? So you get what we call a bundle of rights, and these are things you can do with the work that you created. You can reproduce it, you can display it publicly, you can make derivative works. These are like your mashups. So if you're taking music and you're putting it with a video you made, that's a derivative work of that song and also of your video that you created. You can distribute copies, that's another, and these are exclusive rights of the copyright owner. So you want to keep that in mind as well. And you also get the right with literary and dramatic works, one of your exclusive rights is the right to perform it. And the big question is, well, how do I protect my work? And copyright registration is really your best bet, and I'll get into why that is. It's of the typical types of IP, copyright is probably the easiest and the cheapest to register with the Copyright Office. You can go online. It's $35 to $50 for a registration fee. You submit a deposit copy of your work, and what that gives you is the ability to enforce your rights. So if you think somebody ripped off something you created, somebody stole your theme, somebody stole your plugin code, if you have it registered, that gives you the right to enforce. I mean, of course, you technically have that right, but it gives you a bigger stick to go after people with if you want to, if you think they've infringed your work. Though you need to have registered if you think an infringement, or you hope you never run into one, but if there is an infringement, the other reason to have it registered is because you need, in order to enforce it and go to court, you need to have registered within 3 months of the publication of that work or before the infringement took place. And there is an expedited way to do it, but it's a lot more than $35, and it is not necessarily guaranteed. So it also gives you, registration also gives you a way to collect more damages, or to collect damages against an infringer. And attorney's fees, of course. So, so some easy ways, if you're trying to think of ways to keep an eye out for infringement, if you're putting work out there, a really simple and free way to do it is to set up a Google alert. And this, if you have the name of the work, or maybe you have a book you published, or, a blog post or something, whatever work you're really concerned about, you can set up a Google alert for that. I know I have that for a couple of trademarks that I have, and some other brands and stuff, and I encourage my clients. Of course, there are monitoring services you can get into to use and everything. And then you also have DMCA takedown notices, which I'll get into more if you feel like somebody's taken your work and uploaded it on a site and said that it's theirs. So that's more for like YouTube and stuff. Like I said, registration. And if you think somebody's infringed your work, you might want to consult an attorney, particularly if it's a large company or something. You would probably want to talk to an attorney before you, send off that email or that letter, just to make sure you've got your ducks in a row before, not to say don't contact them, but it's probably the best idea just in case, and there's some bigger issues in play. So real quick show of hands. Has anybody heard that to protect your stuff for copyright that you should mail it to yourself? Okay. Don't do that. It's a myth. It's a myth. Don't do it. Save yourself a stamp, save yourself the postage, save yourself the envelope. It's a myth. Mailing it to yourself doesn't prove anything. Think about it. You could mail yourself an empty envelope with a postmark and stick anything in it. You have to open it to, to get to what's in there. It doesn't prove anything. You're better off going through the Copyright Office with registration. So, like I said, that's your best bet. Gives you your advantages. Again, don't mail it to yourself. Don't do it. And just real briefly wanted to touch on, like I said, I was in-house with a software company for a time, and you get into some really interesting discussions with software with copyright and registering it. Like I said, you have to do a deposit. Well, what the Copyright Office asks for is the first and last 25 pages of source code, which gets into really interesting technical discussions with the technical team, like, well, where does the source code start? Where does it end? What format are we talking about it? And it gets really interesting. I'm actually working with a client right now on something like that they're like, well, what do we need to deposit? And there's also other little tweaks for it if it has trade secrets that you need to redact and different things. So you have to look at what is the predominant element that you want to protect in that, which I could give another whole presentation on registering software, but I just wanted to get into some of those thoughts, because you might, if it's more of artwork, like with games or like a simulation program, it might be more that you're trying to protect the audiovisual elements as in addition to the source code, and you do a separate registration for that artwork. Anyway, so to get into the Digital Millennium Copyright Act issues, this comes up online, in the online context, when you have content that's being posted on the site by others. And so, this is Facebook, this is YouTube, back in the day with MySpace. If you're working with a company that's going to, or a site that is going to have people posting content like this, they need to have a copyright agent, and that agent not only need to publish contact information for that agent, but you also have to register that agent with the Copyright Office so that people know where to send takedown notices and put back notices for that. And the takedown notices are exactly what they sound like. If you think somebody's taken your video or your content and put it up on Facebook or YouTube and said that it's theirs and it's violating your copyright, you send them a notice and you say, hey, Google, take that down. YouTube, take that down. And but if someone else has done that to you and you're like, hey, no, that's actually mine, you can also send, there's a mechanism so you can send it and put it and say, hey, put it back up, it's mine. And it's part of the reason, the reason you need the agent and you have this whole mechanism is that these websites like Facebook and YouTube get what's called a safe harbor. that they're not held liable as long as they're following these procedures, that they're not held liable for people posting infringing content. So you want to, if you're working with a site that's talking about doing this, or somebody that's talking about doing something where people would be posting third-party content, you want to have the agent in place and everything. So something that came up, it was a great question actually I got at WordCamp Tampa, which was, what if I put up a work and somebody, sends a takedown notice and it's wrongful? What if it's, if their takedown notice is inaccurate? And what do I do about that? And there is an allowance, there is a section of the Digital Millennium Copyright Act that does allow for the award of damages for wrongful if somebody sends a wrongful takedown notice. So if they're misrepresenting to the service provider that it's, that it's infringing, then you can get damages. And this gets into an interesting case. With this. So what does that mean? You can get an award of damages. Well, there was a case called Lens versus Universal, and involves, as you may have heard about, it's also been called the dancing baby case, because a woman had posted a picture of her baby dancing to the Prince song "Let's Go Crazy," and Prince's record label didn't like it. And so they filed suit against, they had the video taken down, and they filed suit and said, hey, you didn't have a license to use that song to make that video, and, so it went into a lot of litigation, and one of the things that came out of it was that you can't just get unlimited damages with this, that it has to be limited to kind of, the amount, it has to be what was caused by that misrepresentation in the takedown notice. So, and you don't have to show substantial economic damages. And the attorney's fees, they did limit in this case to the fees incurred in responding to the removal of the material. So just kind of an interesting thing with the wrongful takedown notices. There are, in the grand scheme of things, most of the takedown notices are legit, but there are companies and, trolls, as some people call them, that do these wrongful takedowns, but hopefully you won't have to deal with that. So some best practices with this. If your work is taken down, what do you do? Well, you can send, like I said, the counter notice to get it put back up on YouTube, put back up on whatever site. But you want to just do your due diligence on this and be sure. And make sure that you are really, make sure there's no chance that you're actually infringing that person's copyright in any of that bundle of rights that we talked about earlier. Because part of doing the counter notice, you have to state and swear under penalty of perjury, so this is serious, that your material was wrongly removed, and if you're not, just like you're concerned, just like you might be concerned about a wrongful takedown notice, if you're sending a wrongful counter notice, that can also trigger a lawsuit. So you just want to make sure. Now granted, if it's your picture that you took on today, December 5th, and you can document it and you have your copyright registration, by all means send the counter notice. But if you have any doubt, you might call an attorney before you do a lot of this stuff, if you have thoughts, if you're doubtful on it. Anyway. So with copyrights and best practices, if you're working with like images, I know someone mentioned to me during the break, of course, Getty is the big concern with images. They're very diligent in protecting their rights, and so you want to make sure if you're putting photos, don't just right-click stuff off of Google. Know who owns the work, know what the usage limitations are on that and get a license. There's a lot of websites that you can either buy stock photos or you can take your own. And you want to make sure if you're getting permission, get it in writing. Even if it's an email, that's fine, but you want to get that permission in writing, because we've all had those situations where you do the handshake deal, and then when things go south, everybody's got a he said, she said story, and it doesn't quite work. And I do want to touch on in the next slide, don't just rely on, there's a lot of discussion with fair use, and it is out there, but you want to keep in mind fair use is a defense to a claim of copyright infringement. So by the time you might be arguing about fair use, I mean, granted, you can have an attorney give you an opinion on that, but where the rubber hits the road with fair use probably means that you're either being threatened with being sued for copyright infringement, or you already are being sued. So you want to think about, you want to think through these things and just be smart about it, and just you just want to keep your stuff, figure out, like I said, know who owns the work, get the licenses, keep everything on the up and up, and document what you're doing. And you shouldn't have any problems. And you also want to pay attention to, I wanted to touch on this, on the not just the copyright terms, but also there may be other non-copyright terms too, using like images or graphics that you want to pay attention to. In one of my past lives in my career, I worked at a company, and we had some packaging for a product that was about to go out, and we discovered right before it went to be printed that the packaging for this product contained a photo, a stock photo, that had a term in their license that said no commercial use. So, and that was a big problem, because then we had to stop what we were doing, go back, find a photo, redo the artwork, redo the packaging. It can be a really big issue. So look for things like, if it says no commercial use and you're going to use it for anything that might make money, that could be construed as commercial use, you probably want to get a different picture. Or my favorite is just create your own, if you can. And I just wanted to go through, so fair use, what is that? So it's a multi-factor test under the law, and like I said, it's a defense to claims of copyright infringement. And there's several factors, and I was actually today at lunch talking to a colleague of mine who also does intellectual property law. And the thing we were talking about is, fair use, we have the factors, but the courts vary widely as to how they come out on this. There's no way, it's kind of like massaging a jellyfish. It's not necessarily going to come out one way or in one form. It's very fact specific. It's very dependent on what situation you're in, what judge you get. You don't know. So you just, I'm not discouraging you. There certainly are many cases, where, and that's the thing. There may be cases you can, I'm sure, talk about, that we could talk about all afternoon about, well, oh, this ruling was totally crazy versus this one's totally right on. And that's the spectrum that you're dealing with sometimes. So these factors, the first one they'll consider is the purpose and the character of the use. So this is where you get into if it's for an educational, a nonprofit educational institution versus a multinational, massive corporation, there's going to be a difference in how the court looks at it as to whether it's a fair use or not. So if you're using it in a classroom environment, that may be different than you're using it in the middle of a multi-million-dollar ad campaign. And what's the nature of the copyrighted work? Oh, and yeah, let's do another poll on that. Have any of you ever heard like that there's a certain amount of bars or a certain amount of time in a song that you can use and you don't have to get a license? Yeah, also a myth. Yeah, also a myth. There's no standard. Like I said, it's a squishy area. So there's no bright line on it. And actually, there was just a ruling last month in a case against Georgia State University that found where the university had a policy about what was fair use and what was okay for their professors to use, and the court struck it down and said there is no bright line test. So I wish there was something that simple, but it's a really tricky area with that. The courts have found, that even in the instance of a 500-page book, that if you take the guts of the thing that everybody's going to buy that book for, and you print it, that's infringement. And it may be 300 words out of a 500-page book, but if it's, say, that case, it was Gerald Ford's memoir, and everybody wanted to read the stuff about Richard Nixon and the Watergate tapes, and this magazine just plopped it in their magazine, and the book publisher sued over that, and the court found that that even that small amount could be infringing. So that's the kind of thing you want to think about. And this gets into the next factor is the amount and substantiality of the portion used in relation to the work as a whole. And then the effect on the potential market for the copyrighted work. Are you infringing? Are you taking like the hook of somebody's song and turning it into, the latest Pitbull or the latest, hot pop thing, and you're not getting the license? This is where you get into a lot of sampling issues. That maybe you're impacting the value of the original work. So these are kind of the factors that you get into with fair use. And I just wanted to touch on, you've probably seen Creative Commons as well. And Creative Commons, the idea with this is to give people an alternative to copyright so that they can better, an easier way to license online and make new works and stuff. So you'll have a variety, these licenses, as you go through them, kind of spell out what you need to do in order to use it. So attribution's pretty simple. If you're using that work, you just have to give the copyright owner credit. If it's attribution, you have to give credit, and with the share alike, you have to share it on the same terms. So you can't say, okay, well, I got this from Joe Author, but you can't share it now. Well, if Joe Author has it on, you can share it with everybody, you have to share it on the same terms. And you also have attribution and no derivs, which this gets back to our friend, the derivative work. And so you give credit, but you can't make anything new using that work. You can't, include it with your mashup and that kind of thing. You have to leave it in its original form. And then you have attribution and non-commercial. So give credit, but can't use it for commercial purposes. And then attribution, non-commercial, share alike. So no commercial use on this, give credit, and you have to share it on the same terms. And the attribution, you can see, I mean, it's an important thing, and this will be a theme throughout, because not giving people credit for their work is a really quick way to make people upset. And attribution, non-commercial, and no deriv. So this is no derivative works. So we've talked about copyright, and I want to touch on trademarks. So these are source indicators for goods or services. They are a matter of federal and state law, depending on what jurisdiction you're dealing with. Federal is your best bet on that, because again, it gives you a better enforcement, because it allows you to enforce your trademark across the entire country, as opposed to just in a region. So this can be anything: names, slogans, logos, colors. Actually, you may not know, but Tiffany Blue is actually a trademark, and I remember I was watching some reality show about weddings. I don't know why, but and I remember, I forget what singer it was. I think it was Toni Braxton had to get a license from Tiffany to have a Tiffany Blue, true Tiffany Blue wedding cake. It was pretty interesting. Yeah, college colors can be, yeah.
Can I ask a quick question about nuances of trademarks regarding names and logos?
Sure.
If I have my name, my company name, in a specific font, and say it's printed on my website in an image format but doesn't contain some kind of icon or graphical element, would that be considered the name as being trademarked? Say I registered it as a trademark and I'm claiming common trademark with the TM symbol, would it be considered the name as being a trademark? Or is it a logo, or both?
It can be either, and there's a couple excellent points with that. So one, you touched on the TM versus the circle R. If you want to claim trademark rights in your work, I mean, of course, the standard is first to use the mark in commerce. So if you can prove when you started to use it in commerce, that's your best bet. But of course, you want to register with the Patent and Trademark Office. But you can use the TM like you want to. The circle R, if you don't, you can only use that if you have a federal registration with the U.S. Patent and Trademark Office. So that's one thing to keep in mind. You can trademark just a word mark, what's called a word mark, instead of a design mark, which is more your logos. And with the word mark, that can be advantageous if you think you're going to be maybe changing the font a lot, or if you have maybe a name an image like Google, that they're always doing the doodle and something like that, where you might be changing it a lot, and it might be kind of a pain to constantly be registering all those logo marks, but you might want to do that as well. You'd be surprised how big a trademark portfolio can get. But anyway, long story short, you can do a design mark if you want to do a specific logo that you don't anticipate changing much, that you're going to stick with, but you'd probably still want to do the word mark and the design mark, both as registrations. So does that answer your... Oh. So with the trademarks, these are typically, with the registration fee with the Patent and Trademark Office is $325 to $375. And you also want to keep in mind that trademarks, it's by class of goods or services. So this is why you have Delta Airlines and Delta Faucets, because they're in two different classes of goods and services. But the way the trademark process works is you register, and ideally you would have wanted to do a search, some variation on a search, so that you can not figure out if the name you want is available or not before you go through the registration process, because somebody can oppose your mark. They're published and people can oppose them. Yeah, okay. So anyway, so this can also include scents and sounds. So the 3 tones for NBC. Yeah.
I was having a trademark and it said that it included a state registration fee. Does that mean that it's not federal, or how does that
I'd have to look at it. You normally, normally if you're going through the Patent and Trademark Office, it's usually just the federal fee and not a state one. So I'd be happy to talk to you after about that. So, so yeah, like I said, the strongest protection you have is your federal registration. It's done by classes of goods and services. If you can reserve a mark, if you're maybe in startup mode, you're about to launch a product or you're about to launch a site or service and you haven't had a chance to actually start using the mark, you can register like 6 months in advance. You can do an intent to use application. And the test for infringement with trademarks is the likelihood that consumers would be confused. So if you're confusing somebody into thinking maybe that, that if you're causing somebody to think that somebody else's brand is put out by your company or endorsed by your thing, that's the standard for infringement. And also unauthorized use of marks. And the game Frontierville, I like this one for all my Oregon Trail fans out there, but the game Frontierville, their publisher got in trouble several years ago because they introduced this new expansion to the game called Oregon Trail, and the makers of Oregon Trail were flattered, but were like, hey, you need a license for that. So I think they ended up canceling that expansion. So.
What's the rule on fonts?
They're copyrightable.
I know they are. It seems to me, and you see some, and they're so obvious, like they're supposed to look like a certain companies, maybe like Coca-Cola or something like that.
Mm-hmm.
And if you find them online, very often they'll say for non-commercial use.
Mm-hmm.
But if you just have a collection, you can't always be sure.
Okay.
Unless you use the whole style.
If you license the font, then you can.
Yeah, that would.
No, I'm using somebody else's. I'm thinking.
If it's like a free font online, if it's,
Yeah.
Yeah, that might depend on the terms of the font, but you can register, and that's where you get into if you're registering a design mark. That it might be that you specify a certain font, and that, but it's a good point.
It gets confusing.
Sure. Yeah, I know the internet makes it a little bit like the Wild West, so I'm going to zip through a little bit of this just so we can get to the privacy policies and some other things. But I do want to touch on, so you have a spectrum with trademarks in terms of what's a strong mark versus a weak mark. So you have generic, and these are not protectable. So the example I like to use is Apple. So if you're trying to register Apple for the fruit, the trademark office would say, no, that's generic, you can't do it. Because the idea with the trademark law is, yes, you want to allow people to protect their logos, protect their brand names, but you don't want to take words out of the English language. Because imagine if you had to get a license every time you wanted to go, you went to Publix and said, oh, I want to get an apple. Wouldn't work. You have a descriptive mark, that might be available for, might be able to be registered, but you might have to show secondary use. Suggestive marks are stronger on the spectrum because they kind of suggest but are a little more they're not just generic for what it is. And your strongest marks are arbitrary and fanciful. So going back to our Apple example, Apple for computers, that's kind of arbitrary, that's and you also have Kodak and Exxon, these made up names. And if you've ever wondered, also going back to the trademark search thing, if you've ever wondered why some of the companies have such strange names anymore, it's either that the trademark wasn't available or the domain wasn't available. Usually, which if you're going to a startup weekend and take a couple minutes, have somebody take a couple minutes if you're looking at launching something, at least have somebody do a quick PTO search or whatever. So I did also want to touch on, because we are talking about the web, and it's a big thing in the interwebs in terms of trademarks right now, are the new generic top-level domains. So, and kind of appropriate for WordCamp, one of the new ones, I got an email today from GoDaddy that was apparently .press is available now if you'd like to register anything at .press. And it's a concern for trademark owners, and in particular because of the scale of it. So ICANN opened up these new domains to potentially be registered, and they had 1,900 applications applied for with ICANN to administer these. And so you have everything from .app was one of the most popular, .blog, .book kind of surprised me. We have my favorite, .soc. Concerned about their data. We have a lot of laws for it, and this is a great example. People are really concerned about what you're doing with their data and their stuff. This was, as you may be aware, Facebook has been doing some experiments and surveys. And I got this survey, and it said, you know, how much does this look like an ad? How much does this post feel like an ad? This is a picture of my friend's baby. And I was a little creeped out. And don't worry, I had to get permission to use this because my friend is also a lawyer, so I had to be really careful, be like, I want to put your kid in my WordCamp talk, is that okay? You know, but it freaks people out. People want to know, of course, we're in this new, you know, online environment where, yeah, you want to share with people, but you also want to know, what are these operators doing with all your data? So that's why the privacy policies are important. And they're part of your terms of service, and they're really important. But most people, let's face it, do we all just click accept? Yeah. And unfortunately, here's kind of my estimation maybe of why. Just trying to update my software and make that pop-up go away. Thank you, Java, for updating for the 17th time today. Or just, oh, so much tiny font. Just take me to my download already. I mean, I know. I love reading this stuff. I know not everybody does. So, you know, but it's enforceable, though. These are enforceable in court. These can be enforced against you. So you want to know and also help your clients with, you know, making sure they have these things covered. So we have a lot of species of privacy laws. You know, we have everything from FERPA, which handles educational records, HIPAA for medical records, which I know has become a big thing with the electronic health records implementation, which also makes it interesting. I was at the doctor the other day, and it makes for a different visit when your doctor's cranky because his computer doesn't work and his whole office is down. But yeah, and then we have COPA for children's online privacy protection, CalOPA. We've got new state privacy laws about passwords, EU data privacy, cloud, mobile payment stuff. Yeah, we've got a lot of species of stuff running around. And these privacy laws influence what goes into the terms of service and the end user license agreements that you run into. And you got to keep in mind with, you know, and not only in creating sites and helping clients create sites for clients, but you also want to keep in mind when you're on sites and posting things, you know, they're the rules of the road. They're governing what you do. And an example I always like to use with this is, you know, the online Star Wars game. When it first came out, there was a guy that had gotten, you know, to a pretty high level, and he'd finally gotten his lightsaber. And then he did something, and he violated their terms of service, and they took his lightsaber. And he was like, hey, man, you took my lightsaber. And they were like, hey, man, that's our lightsaber. Go read the terms of service for the game. You know, I know, kind of sad for Star Wars fans. I'm not, you know, but they govern what you do, and you know, it may be just a virtual lightsaber, but you know, it could be a lot more serious if it's something that affects your business. And another thing I wanted to touch on, this was really interesting. I have a couple friends that use Snapchat, and this exposed me to with apps. So Snapchat, the messages only last a very short period of time, or at least that's the thing. But then they came out with all these other apps that let you save the Snapchats longer and whatever. And I installed one of them called SnapHack. I wish I had taken a screenshot of it because I haven't been able to replicate it. But this little pop-up came up and said, hey, using this app may violate the terms of terms of use for Snapchat, and we're not responsible if Snapchat shuts your account down for using our app in conjunction with their app. So you want to think about if you're working on an app that maybe uses Facebook's API or uses any of these APIs to work with these other networks, you want to make sure you're not doing something that might, or if you are, maybe put one of those pop-ups up that say, like, we're not responsible if we get your account deleted. So just a thought. So have you ever wondered, and some of you may know this already, but have you ever wondered why you have to click boxes on websites or put your birth date in or say that you're over the age of 13? Okay. Well, it's because of the Children's Online Privacy Protection Act from 1998. And this basically prohibits website operators from collecting or disclosing personal information from minors under the age of 13 without verifiable parental consent. So you have to have notice of this, you have to tell what you're collecting, how it's used, And even if you get the parental consent, you still have to have this in your privacy policies. You have to have this, and it's not just for kids sites. This applies to anything where kids might get into that, might be using it. So if you're collecting even Sony Music, Yelp recently got into a settlement with the FTC over this because, and it was ironic, Yelp had all the COPA filtering mechanisms on their website, but not on the mobile app, and that's what got them in trouble. So you want to make sure if you're working on an app, you want to have the same mechanisms for screening on both. And that's why some sites just don't let people under the age of 13 on there. But then again, we also know, I'm sure I'm not the only one with friends' babies who have their own Facebook profiles now. It's like, I know they're not 13. And I want to jump into, and then we'll get to open source. I know we're running short on time, but so they updated COPA, the Federal Trade Commission updated COPA in 2013, and they've expanded the definition of personally identifiable information. And now this includes geolocation data. It includes persistent identifiers that could identify you across multiple websites, or those handy things that keep you signed in on Facebook from every site. So that can be cookies, IP addresses, mobile device IDs. Those are all considered as well things that you need to disclose and get consent to collect from minors. And these don't even have to be of the child. So it could be a photo or audio file of something containing the child, but it could also be something that could identify that child. So maybe a picture of their parents' house, picture of their parents, something that you could use to identify that child. And I was talking to a friend who was working on a website for a school, and the first couple times we talked about it, he was like, oh, I don't think there's a COPA issue with it. And then finally, the second or third time we talked about it, I said, well, could you go in and identify, I'm like, is it by classroom? And he's like, well, it doesn't have the kids' last names. And I said, yeah, but could you figure out that Todd R. is in Mrs. Smith's class in the 3rd grade? And he goes, oh, yeah. And he ran it up the flagpole because he was doing some contract work, and it turned out the higher level manager was aware of the issue, and my friends had flagged it, but the middle level person wasn't necessarily aware. So you just want to run it up the flagpole if you're doing like freelance or contract work, or just in general. You just want to flag it if you think that there might be an issue that's not being dealt with. And then California has put out their own version of this, and it applies to all Californians, not just minors, and requires that you have to have conspicuously post your privacy policy to inform consumers about what data you're collecting and with which third parties you're sharing that data. So, I know you're thinking, well, we're sitting here in Florida, but with the internet, you could easily be dealing with California citizens and get into issues. So you want to make sure that it's conspicuously posted. And I know we all want everything to be designed and pretty and everything. I know privacy policies aren't pretty, but you got to find a way to make it pretty so it's conspicuous and avoid running into issues with this. And some new requirements are coming online the 1st of next year. Yeah.
Page in the footer, a direct link to that, is that conspicuous?
Like a
Does it
footer
need to be in the header?
Well, I think a link would be fine, but it's just, you can't have it super tiny. You can't have it where like it would be, where if you'd have to dig for it, if you feel like you'd have to really dig and dig and dig, that's probably more toward the side that you want to stay away from. And going back to apps, Delta Airlines got in trouble with the Attorney General of California for having an app that didn't have the privacy policy, posted to it. And I've seen some different ways that people are trying to comply with this, particularly with online games. I'm one of those social game people. Forgive me. It's research, I swear. But I've noticed some of them, they'll have an ad in there and it bounces to Yahoo's privacy policies and stuff, and that might be great if it's, if those terms match with what you're doing. But you don't want to just include a link to generic stuff that, because what your app might be doing might be different than what Yahoo's doing. So you just want to make sure it's matching for what data you're actually collecting and how you're using it. So.
Whose responsibility is it in working with a website developer to have privacy notices and terms of service included in the site?
It's on the operator. So if you're developing the website, that may not be on your thing, but
What if you're hosting the site for the business?
Well, would still be on the business. If they're operating it and controlling what content's going up, if you're just hosting it, that may not be enough to make you potentially involved in this.
Certainly we should be advising.
Yeah, well, you want to, we all like to look smart. You want to be developing and go, oh, hey, did you hear about those new requirements with CalOPA and that kind of stuff? You want to look sharp. I like to arm my clients with information and and help them out. So to touch on this I know we'll breeze through open source. It'll be fun. But some new requirements with CalOPA coming on. There's going to be a requirement called like a delete button, and this would, if you're a retailer, would require you to have some mechanism to allow a minor to request the deletion of their content that they've posted. So if you have anybody under the age of 13, that if they send you a request, send a request to the operator, that they would have to delete that, and you have to provide them with notice of how to do that. And then there's certain categories of products that you can't market to minors. So again, this would be on the website operators. So they've entered into an agreement with some of the big operators on this that would, so your App Store, your Google Play, that they've agreed to provide consumers with an opportunity to review the app's privacy policy before they download it, and working to educate app developers on the privacy obligations and develop tools for consumers to report non-compliant apps. So if you're working in the app space, this is going to continue to be an issue, so you want to be aware of it. But hopefully, the big app people will be providing you with mechanisms and all this education on how to comply with your privacy obligations. So some best practices on privacy policies and advising clients with it. You want to treat it like a living document. So keep it current. Revisit it often. Like I said, stuff's coming in January 1st that might change how you have things. Keep it prominent. Again, conspicuously posted. Treat it like a living document. Treat it like a plant. You got to water it, give it some sunshine. Poke it occasionally. And revise it often as your needs change. Maybe you're changing the type of data you're collecting. Maybe you're changing who you're sharing it with. You want to just adapt it as you need, and you want to stay abreast of FTC rulings and developments in this area as much as you can. If you're doing something targeting kids, particularly apps or games targeted at kids, you want to be really careful about your COPA and CalOPA compliance on that. And you also want to protect the data you're collecting, or make sure the third party that has your data is up to snuff on protecting it. So, and another big point I like to make with this is collect only as much data as you need. There was the case of that flashlight app that when you installed it, it asked for access to your contact or your address book. It's a flashlight app. Why does it need all my friends' addresses? That's like, you got to think about, go within, make it simple for yourself. Don't have an app that's getting into every aspect of a user's thing if you don't need it to run the app. So just touch on open source for a little bit, though I know we're running 2 minutes. Okay, so sorry about this, y'all. I could talk about this stuff all afternoon. Anyway, so we're pretty familiar with it. Big thing, what does the license say? So we want to jump to, we have the spectrum. So you have everything from the beer license, which is you can do whatever you want with this software, as long as if you run into me in a bar and you find out that I wrote that code, you have to buy me a beer. You have everything from that to GPL2, GPL3, which, from a lawyer's perspective, I view as more restrictive because it requires you to do more things. Or as came out of one of my talks at Drupal Camp, we call it militantly open. So in that there's more requirements for you to have to keep that open source, and that can be a problem with proprietary stuff. So and just give me the hook whenever, and we can do questions. So, okay.
Actually, we're kind of running quick on it. About 5 minutes for questions, because
okay.
Talks ended really early. So
oh no. Okay. So sorry guys, but I will make the rest of the stuff available. So don't worry. So yeah.
I've been for a lot of local mom and pops, and for example, I have a locksmith, like John Smith.
Mm-hmm.
And his registered business name is John Smith Locksmith Services LLC. But he buys 10 domains, like all Is that too broad for this, or?
So he's putting that for all the content on the website, or
Domains.
okay.
You can try and get like landing pages for certain niches, like locksmith, or residential locksmith, or locks being changed, so you can buy those domains.
Yeah.
But at the bottom, do you understand what I'm saying, that there's something generic for the footer?
Well, so the all rights reserved, that refers to the copyright with that. There's a couple issues with in there, so I don't know that I can totally get into it in 5 minutes. So I'm happy to talk with you after. So way in the back.
I had a question about copyright. All websites at the bottom, you'll see what says copyright 2014, whatever the year is.
Yeah.
At the beginning of the speech, you said copyright costs $35 each. So does that mean that if you're doing a website, you have to have a license for each page, for each paragraph, or is it a website? And is there one place where you can find out if somebody has registered a copyright?
Well, so the registration is $35. And I wanted to jump to this because talking with the year, so you want to go to the year of creation. So you'll see at the bottom, and this used to be a requirement to get copyright protection. Under the new law, you don't have to do this, but it used to be that if you didn't have the copyright year and the notice with the year and the owner, that you didn't get any copyright protection. If you didn't have this, you blew it. And by the way, this is not how to do open source. You actually have to fill the template in. I've run it. Anyway, sorry. That's another story for another day. But remember, when you're copying and pasting the documentation, you have to fill this in. Because I've run into where I've had somebody on the technical team wanting to use a piece of code. And when we went back, we couldn't provide attribution. We couldn't do what the license asked us to do because it said, fill in the blank, and we were like, great, okay, so we're going to use something else. So does that? But
Well, and then you spoke of, there's a fee for it, but a lot of people just put that bottom.
right. Well, so okay, so I get what you're saying. And the copyright, what I was saying is, so when the copyright protection technically vests whenever you fix that idea in a tangible medium. So that goes to writing it down, creating the code, buffering, and the copyright protection vests. The $35 is you register that with the Copyright Office, and that's your best bet to protect it. That's documenting that you created it and providing you with that means to prove that you have a certificate that you created it instead of
Do you have to do that for each page, for each paragraph, or could you just get one for the whole site?
You could do one for the whole site. You can do like a collective work. It depends. So, yeah.
What are your thoughts on the terms of service and privacy policy generators that are floating around out there?
I think they're probably a good place to start, but like I said, you want to go through it though and see, does it match what you need? It might give you a good skeleton, but you still want to look at, is it, are there paragraphs in there that don't apply to you at all? Is it designed that maybe you're not even collecting user data, to a certain extent? Maybe you don't have an email newsletter, so maybe you don't need sections about that. Could be a good place to start. Maybe if you don't have the budget for two, maybe, have somebody write you one from scratch. So,
Last one.
oh, okay. Yeah.
I think we need to level.
I will be around later too, so I'm happy to talk to people. So yeah.
So with copyright and images and attribution, or all the attribution levels, does cropping an image count as a derivative of an image?
Technically, yeah. Technically, that's you're creating a new work from the original one. So, yeah.
We have a project we're getting ready to launch, and I think there's probably something we want to hire you to run some stuff by. Is there a way to get in touch with you, like
Yes. I have cards, and I'm around. And then, and you can also follow me on Twitter at punklawyer or at Chrissie Scelsi. So.